Can you imagine the U.S. government going after immigrants just for, well, disagreeing with its policies?
Yeah.
For speaking out?
Yeah.
That's really the core of what we're digging into today.
Sure.
The First Amendment rights of immigrant activists.
It really is. It's a question that hits right at the heart of what free speech means, you know?
Mm-hmm.
We're drawing heavily on Alina Das's paper, Protecting Immigrant Activists from U.S. Government Retaliation. It's a fantastic resource.
Right.
It looks into the legal and also the sort of systemic hurdles that activists face when they think the government is retaliating against them. And she suggests some solutions, too.
And for you, the learner, this isn't just some abstract legal thing. Immigration, it touches so much of American life.
Absolutely.
Understanding who gets to speak out on it without fear is, well, it's crucial for understanding how our society works.
Mm-hmm.
And here's something that might genuinely surprise you. The government has actually argued in court that certain immigrants, they just don't have any First Amendment rights at all.
It's a pretty startling claim. Let's unpack that.
Okay, so to set the stage, it's really important to get this. Speech about federal immigration policy should be, among the most protected kinds of speech under the First Amendment.
Okay.
Because it's fundamentally about a matter of public concern, something we're all talking about. It affects a lot of people.
Right. It's not some private dispute.
Exactly. And think about it. The Supreme Court in City Houston v. Hill basically said that the freedom to challenge or even just verbally oppose police action, that's a key difference between a free nation and, well, a police state.
That's a powerful idea. Liberty means being able to question authority.
Precisely. And you see it again in Snyder v. Phelps, the funeral protest case.
Mm-hmm. Very controversial.
Very. But the court was clear. Speech on public issues gets the highest protection. The main point is that criticizing power is just essential in a free society.
Okay. And there are other cases reinforcing this. Yeah, cases like Connick v. Myers and Gentile v. State Bar of Nev, they also emphasize this special protection for speech about public issues and, crucially, speech that criticizes how the government uses its power.
So questioning the state, fundamental.
It's a cornerstone.
Okay, so in theory, it sounds crystal clear. Anyone in the U.S. speaking about immigration policy should be protected.
That's the theory.
But as Alina Des points out, when you actually look at how things play out in the immigration context, it gets messy fast.
Yeah, it really does.
What complicates it? What throws a wrench in the works?
Well, a big piece is history. The U.S. actually has a long history of using immigration laws to clamp down on dissent.
Really?
Oh, yeah. Julia Rosekraut talks about this in her book Threat of Dissent. Think way back to the Alien and Sedition Acts.
Right, from the early days of the country.
Exactly. Or the Palmer raids after World War I, deporting suspected radicals. Or later, deporting alleged communists and anarchists during the Cold War.
So this isn't a new phenomenon, the government potentially using immigration status to quiet critics.
Not at all. It shows this pattern using immigration powers to silence views the government doesn't like.
And what about this plenary power doctrine? That sounds kind of ominous, like it gives the government carte blanche.
It's definitely part of the picture. Plenary power. It's a doctrine the courts basically created themselves. And historically, it's meant that federal courts have been very, very reluctant to second-guess Congress or the president on immigration matters.
Especially if national security is mentioned.
Especially then. So this deference, it kind of created this space where there's just less judicial oversight of what the government does in the immigration field.
And that ties into court decisions.
It does. It's part of why the Supreme Court's 1999 decision in Reno v. AADC, that's the American Arab Anti-Discrimination Committee case, limited the ability of immigrants to claim they were being selectively enforced against in deportation proceedings.
Because the courts didn't want to interfere with who the executive branch chose to deport.
Pretty much. There was a real hesitation there. But importantly, even in AADC, the court carved out a potential exception.
Oh.
Yeah, for truly outrageous discrimination. So not a total blank check, but still a high bar and a lot of deference.
Okay, so that history and the plenary power idea created an environment where maybe government overreach could happen more easily.
You could certainly argue that. It set the stage.
Which brings us to more recent times, because we have heard a lot of allegations about retaliation against immigrant rights activists, especially, say, during the first Trump administration.
Yes, quite a few.
The number of incidents reported is actually kind of staggering, isn't it?
It really is. The NYU Immigrant Rights Clinic and its partners, they documented over 1,000 instances of what they argued was First Amendment retaliation.
1,000.
Yeah. And these weren't minor things. We're talking about IC allegedly targeting well-known immigrant rights leaders for deportation in places like New York City and Seattle.
Targeting specific people because of their activism.
That was the allegation. Detaining people soon after they publicly criticized ICE. There was even that case of a grandfather, an activist, who was detained and deported right after a documentary about him premiered at Sundance.
Jeez. Those examples really drive home the potential human cost.
Absolutely. They underscore what's at stake in these legal fights.
It definitely raises the question of whether government power was being used to silence dissent. Now, the Biden administration issued some guidance saying basically, don't use First Amendment activity in enforcement decisions.
Right, DHS guidance.
But have these kinds of reports stopped entirely?
Unfortunately, no. Reports of alleged retaliation, especially against maybe more vulnerable immigrants, they've continued.
And the alleged consequences sound really severe.
They are. We're talking fines, being put into deportation proceedings, sudden detentions, being transferred far away from family or lawyers.
Solitary confinement, even.
Solitary confinement, yes.
Yeah.
Rapid deportations. And beyond the direct harm, there's the chilling effect.
Meaning people become afraid to speak up.
Exactly. If people fear that speaking out, organizing, criticizing could lead to being locked up and kicked out of the country, they're obviously much less likely to do it. It silences entire communities.
Which leads us to maybe the most disturbing part of this whole thing. The actual legal argument that some immigrants just don't have First Amendment rights, period. This came up directly in that Pineda Cruz v. Thompson case, didn't it?
It did. And it was, frankly, an alarming position for the government to take. Pineda Cruz involved mothers who were detained while they were seeking asylum.
Right.
They protested the conditions in detention. They circulated a petition, went on a hunger strike. Basic acts of protest.
And the government's response?
Their legal argument in a motion to dismiss was that these individuals, because they'd arrived recently, didn't have authorization, yet they fell outside the protection of the First Amendment.
Well, let's really break that down. The government was saying, essentially, if you don't have enough connection to the United States, you just don't get free speech rights here.
That was the core of their argument in that motion, yes. Lack of sufficient connections meant no First Amendment protection.
That sounds radically different from how we usually think about rights in the U.S., like a tiered system based on status or how long you've been here.
It definitely raises profound questions about who counts as part of the people when we talk about fundamental rights within our borders.
So what happened in that case? Did the court agree?
Actually, the case was voluntarily dismissed before the court ruled on that specific First Amendment argument. But the fact that the government made the argument is what's concerning. It suggested a view of almost unchecked power over certain non-citizens inside the U.S.
But is that actually the law? Has the Supreme Court ever said that people without lawful presence have no constitutional rights?
No, it hasn't. That's crucial. The Supreme Court has not endorsed that broad view. In fact, think about Plyler v. Doe.
The case about education for undocumented kids.
Exactly. The court applied equal protection principles there to say Texas couldn't deny those children a basic public education. That certainly implies constitutional protections apply regardless of lawful status.
Okay, so Plyler points the other way. What about that case, Verdugo-Urquidez? Does the government use that one?
Sometimes it's brought up. Verdugo-Urquidez was about whether the Fourth Amendment's protection against unreasonable searches applied to the search of a non-citizen's home in Mexico.
Ah, outside the U.S.
Right. The court said the people protected by the Fourth Amendment didn't extend to someone abroad with no voluntary connection to the U.S. But, and this is really important, that was about the Fourth Amendment outside the U.S.
And the First Amendment might be different.
Legal scholar Michael Kagan makes a strong point here. He notes that the First Amendment's free speech clause, unlike some other parts of the Constitution, doesn't actually specify who gets to speak. It just says, Congress shall make no law abridging the freedom of speech.
Interesting. So the focus is on limiting government power, not defining the speaker.
That's the argument. It suggests a broad public interest in preventing the government from suppressing speech, whoever is speaking. And besides, how the government treats immigrants in detention. That's absolutely a matter of public concern.
And we need to hear from the people experiencing it to understand it.
Their voices are vital for public understanding and accountability. You can't have an informed debate otherwise.
Okay, so let's say an activist believes they are being retaliated against for their speech. What legal doors can they knock on? How do they get a court to even listen?
Well, the basic way into federal court for constitutional issues is through what's called federal question jurisdiction. It comes from Article 3 of the Constitution and a federal law. It basically gives federal courts the power to hear cases about federal law, including the Constitution.
So a First Amendment claim is a federal question.
Yes. And the Supreme Court has also said, in a case called Webster v. Doe, that courts should try hard to avoid interpreting laws in a way that completely shuts the door on someone making a credible constitutional claim. There's a presumption in favor of judicial review for those kinds of claims.
And what about challenging detention itself?
There's habeas corpus. The suspension clause in the Constitution protects the writ of habeas corpus, the ability to challenge unlawful restraint on liberty. Federal law provides the mechanism for this. It's a fundamental check on executive detention power.
Hasn't the government often argued that, in the immigration context, activists can't actually bring these retaliation claims to court using that AADC case again, and a specific law?
Yes, that's been a major battleground. The government frequently points to Reno v. AADC and a part of the Immigration and Nationality Act, 8 U.S.C. Section 1252G, to argue that courts lack jurisdiction, that they can't review these claims.
What did Section 1252G and AADC actually say about limiting review?
So, Section 1252G specifically limits judicial review of 3 particular discretionary decisions by the Attorney General, decisions to commence proceedings, to adjudicate cases, or to execute removal orders. In ADC, the claim was selective enforcement, that they were being targeted for deportation because of their political affiliation with the PFLP.
Okay.
The Supreme Court said Section 1252G did apply to that specific claim about the decision to commence proceedings based on their affiliation, essentially limiting review of that kind of selective prosecution claim in that context. The court was reluctant to get into the government's motives for choosing to deport someone based on group affiliation, especially one linked to terrorism concerns.
But did AADC say no constitutional claims related to deportation could ever be reviewed? Was it that sweeping?
No, not quite, and this is really important. The majority in AADC specifically left the door open for reviewing claims of, again, outrageous discrimination.
Ah, that exception again.
Yes. And Justice Ginsburg, in a separate concurring opinion, was even more explicit. She worried about situations where someone might have a serious constitutional claim, like a First Amendment claim, that couldn't really be properly addressed during the regular deportation hearing process.
A now or never situation, she called it.
Exactly. She suggested that in those kinds of now or never cases where there's no other adequate forum, courts might need to step in, notwithstanding Section 1252G.
And this is where that Second Circuit case, Regbier v. Holman, becomes so significant. They picked up on that outrageous discrimination idea.
Precisely. Regbier involved Ravi Regbier, the director of an immigrant rights group in New York. He'd lived in the U.S. for years, reporting regularly to IC under an old deportation order. Then, suddenly, he was detained during a routine check-in.
And the claim was retaliation.
Yes. There was evidence suggesting an ICE official resented his public criticism of the agency and his advocacy work. The Second Circuit Court of Appeals looked at this and said, yes, First Amendment retaliation can qualify as outrageous discrimination under the AADC exception.
How did they decide that? Did they set out a test?
They did. They outlined several factors to consider: the nature and importance of the right affected, whether the conduct was actually constitutionally protected, how bad the government's alleged actions were, and balancing the individual's rights against the government's interest in enforcing immigration law.
And applying that to Ragbir's case.
They found his advocacy for immigration reform was core First Amendment speech. They felt that letting the government retaliate against him for that speech would have a massive chilling effect, stopping others from speaking out on important public policy.
So the potential harm wasn't just to him, but to public debate itself.
Exactly. And they distinguished AADC by noting that AADC involved national security concerns linked to alleged terrorist groups, whereas Regbier was about alleged retaliation for criticizing the agency itself, a very different context.
And they also said the suspension clause, the habeas corpus protection, guaranteed review in his case.
Yes, because he was in custody under a deportation order, they concluded the suspension clause ensured he had a way to challenge the lawfulness of that custody based on his First Amendment claim.
Okay, that makes sense. Now, another big Supreme Court case mentioned is Department of Homeland Security v. Thurisigium. How did that impact things? Did it roll back protections?
Thurisigium was a bit narrower than some initially feared. It dealt specifically with the scope of habeas review for asylum seekers who are caught right at the border in what's called expedited removal.
So not people already living inside the U.S. for years, like Ragbeer.
Correct. The court did narrow the scope of habeas review in that specific border context, focusing mostly on whether the detention itself was lawful according to statute. But importantly, the court explicitly said it was preserving earlier precedents, like INS v. St. Cyr, which confirmed habeas review is available for people inside the U.S. facing deportation who want to raise legal and constitutional questions.
So it didn't dismantle habeas review for people already here.
No, it reaffirmed the availability of habeas for statutory and constitutional claims for those within the country facing removal, and it also maintained the general idea that there's a presumption of judicial review when someone's liberty is restrained.
Got it. And the government sometimes tries other legal arguments to block review, using different parts of that same immigration law statute, 8 U.S.C. Section 1252.
Yes, they sometimes point to sections like Section 1252A5 or B9, but generally those sections are understood to limit challenges to the validity of the final removal order itself, like arguing the immigration judge made a mistake in ordering deportation.
Not separate claims about why the government decided to enforce the order, like retaliation.
Exactly. Those sections aren't really aimed at blocking independent constitutional claims like First Amendment retaliation, which aren't challenging the order's validity per se, but the reason for its enforcement now. So courts generally still find ways to hear these credible retaliation claims, whether through habeas, the AADC exception, or just basic federal question jurisdiction.
It seems like a key principle here is that even if the government can legally do something, like deport someone with a final order, it can't do it for an unconstitutional reason.
That's a fundamental point.
Like that case involving the professor, Perry v. Senderman.
Exactly. Perry established that even if the government doesn't have to renew someone's contract, like a professor's, it can't refuse to renew it because the person exercised their free speech rights. The government's authority isn't absolute. It's constrained by the Constitution.
And there's a legal test for figuring that out if there might be mixed motives.
Yes, the Matt Healthy test. It's a burden-shifting framework. First, the person claiming retaliation has to show their protected speech was a substantial or motivating factor in the government's adverse action.
Okay.
If they show that, the burden then shifts to the government to prove that it would have taken the same action anyway, even if the person hadn't engaged in the protected speech.
So the government can still act if there was a legitimate, independent reason.
Yes, if they can prove it wasn't the speech that drove the decision.
Now, another government tactic seems to be trying to import standards from criminal law into these civil immigration cases, like the Neves v. Bartlett case.
Right. In Neves, the Supreme Court dealt with retaliatory arrest claims under the Fourth Amendment. It said that, generally, if the police had probable cause to make the arrest, the person arrested usually can't bring a First Amendment retaliatory arrest claim.
Because arrests often happen quickly, and it's hard to figure out the officer's subjective motive if there was objective probable cause.
That was the reasoning. And the government has tried to argue this Neves standard requiring a showing of no probable cause, or, in the immigration context, no valid legal basis for enforcement, should apply to First Amendment retaliation claims in immigration, too. They argued this in Bellares v. Gaynor and also in Ragbeer.
But courts haven't really bought that argument in the immigration context.
Largely, no. Courts like the Second Circuit in Ragbeer push back. They reasoned that immigration enforcement is civil, not criminal. Actions like detention or initiating deportation are often pre-planned, involving deliberation, not necessarily those split-second decisions police make on the street.
So the rationale behind Neves doesn't fit as well.
Right. Plus, as we discussed, the AADC framework already sort of deals with the concern about probing the government's motives in selective prosecution-type cases in immigration. Retaliatory detention or deportation for speech feels like a different kind of claim.
And wasn't the Ragbeer case ultimately sent back by the Supreme Court? Did that undercut the Second Circuit's reasoning on retaliation?
The Supreme Court did vacate the Second Circuit's decision in Ragbeer, but it was on a separate, narrower jurisdictional question related to Section 152. They didn't actually rule on the merits of the Second Circuit's First Amendment retaliation analysis or the outrageous discrimination standard, so that part of the reasoning wasn't overturned.
Okay, so the idea that just having a valid reason on paper, like a prior deportation order, automatically blocks a retaliation claim isn't necessarily the final word.
Correct. And even the Neves rule itself has exceptions that could potentially apply here.
Ooh, like what?
Well, one exception, from Lozman v. Riviera Beach applies if the retaliation is based on an official government policy or is part of a broader orchestrated campaign of retaliation. In those cases, the probable cause issue might not be a barrier.
Because it points to a systemic problem, not just one officer's decision.
Exactly. Another Neves exception is for situations where officers typically exercise discretion not to arrest someone, even if they technically have probable cause.
How does that relate to immigration?
Well, immigration enforcement involves enormous prosecutorial discretion. IC decides who to focus on, who to detain, who to release, who to seek deportation against. There are millions of people potentially subject to removal, but only a fraction face enforcement action.
So if an activist is targeted, and you can show that people in similar situations aren't usually targeted, that might fit the exception.
Potentially, yes. If you can provide objective evidence, as the Supreme Court discussed more recently in Gonzalez v. Trevino, showing that you were treated differently from similarly situated individuals, and that the government typically exercises discretion not to enforce the law in those circumstances, that could overcome the Neves barrier even if there was a technical basis for enforcement.
This legal landscape is definitely complex. But Alina Dass's paper, it doesn't just focus on lawsuits, right? It talks about other strategies, too.
Absolutely. Litigation is just one tool, and often a slow and difficult one. She emphasizes the importance of proactive strategies.
Like what?
Things like community trainings, know your rights workshops, so activists understand the risks and their potential protections. Documentation is also key, carefully recording any incidents of suspected retaliation.
And getting the word out.
Yes. Public education, media outreach, political advocacy. Shining a light on these practices is crucial. This involves creating reports, holding teach-ins, using Freedom of Information Act requests, or FOIA, to get government documents.
Filing complaints with oversight bodies.
Exactly. Filing complaints with internal watchdog groups within DHS, like the Office for Civil Rights and Civil Liberties or the Inspector General. It's about creating pressure and demanding accountability outside the courtroom, too.
And ultimately trying to change the system itself to prevent retaliation.
That's the long-term goal. Pursuing structural reforms through new legislation, through administrative policy changes, through new regulations.
What kinds of reforms are we talking about?
Things like clearer guidance on prosecutorial discretion, making sure First Amendment activity isn't a factor, reaching settlements in lawsuits that include policy changes, strengthening internal oversight mechanisms, creating clear rules and pathways for people to report retaliation and get relief, and pushing Congress to clarify or restore judicial review where it's been limited.
Have any of these ideas gained traction?
Some have. As we mentioned, the Biden administration issued DHS guidance discouraging retaliation for First Amendment activities. There have also been settlements in some key cases that included protective measures.
And looking forward, what's on the wish list?
Advocates are pushing for more concrete changes. Things like actual regulations, which are stronger than just guidance that would require terminating retaliatory deportation proceedings. Changes to rules that currently bar people from returning to the U.S. if they leave while fighting their case. Giving more power to internal investigators. Revising detention standards to better protect rights. Lots of ongoing work.
Okay, so wrapping this all up, this deep dive really shows that immigrant activists, well, they face some serious hurdles, both legal and systemic, when they try to challenge what they see as retaliation for speaking out.
Yeah, significant barriers.
And even though free speech feels so fundamental, we've seen the government itself argue against their rights, argue against their ability to even get into court sometimes.
Yeah. But the legal challenges, the advocacy, the organizing that continues, people are constantly pushing back.
And for you, the learner, this really highlights just how complex constitutional rights can be when they meet specific high-stakes situations like immigration enforcement. It's not always black and white.
Definitely not. The debate over where the lines are drawn for free speech, especially in this context, is very much alive and ongoing.
So here's a final thought to leave you with. When you consider the history we talked about and these ongoing concerns about potential government retaliation, what does that mean for our democracy? What are the long-term implications for participation, for government accountability, if whole groups of people living in the U.S. feel they can't safely criticize government policy?
That's a really important question.
It forces you to think hard about that balance between, say, national sovereignty and security, and these really fundamental human rights, like the right to speak your mind.